Alright, your abatement action. Section 106, with addition with any of the other action, take with the state of the local and the president determines that they would have made the imminent substantial endangerment of the public health, the welfare of the environment, to cover the action with threat and relief of the hazard something of the facility he may be required of the Attorney General of the United States to secure for the job of the relief of the necessary debate with the of the general danger or threat of the district of the United States of the district in which the threat occurred with the search of the jurisdiction grave the relief of the public interest equities equity for this case of the required by the president may also with the after notice to have the effect of the state of the action under this section include but not limited to issuing such orders may be necessary to protect the public wealth, health, welfare, and environment. Any person with who is significant sufficient call of the willfully viable and fail with the refuse to comply with any of the president under subsection A of the action bureau with the appropriate understated district court with the to enforce such order that they find not more than $25,000 each for the state of the device each day with such violation occur with the of the failure can comply. Continue. To a person with the receipt of the comply with the terms of any order issued there in subsection A may comply within 60 days after the completion required in petition of the president and reimbursement of the fund with the reimbursement will cover the such action plus of the interest payable under the paragraph shall occur the amount of the expended with the date of the expenditure of the self name of the rate specified by the interest rate and investment of the head substance superfund with the establishment of chapter A of chapter 1988 chapter 98 out of the Internal Revenue Code 1954 of the paragraph that refute the grant involved the part of the petition on the paragraph of the petition within 30 days of the recipient receipt with the step of the refusal you with the accept of the against for the president and appropriate United States of the district court with the reimbursement of the fund. Except for the paragraph of subparagraph D with the obtaining the reimbursement of the petitioner with the self of the preponderance of the evidence of the not liable reasonable cover in section 107A with the call for the seek with the reimbursement of the reasonable list of the action required in relevant order. Alright, a petition will liable to be responsible for the call for the section 107A with the recover the responsible for the call for the response to the extent whether it can be demonstrated for the minister for the record of the president decisions like for the response to action order with the arbitrary capture otherwise not according to the law of the reimbursement or the paragraph of the shall include all reasonable call that incurred by the petition or the presumed the proportion of the other found within the arbitrary carriage for the otherwise not in accordance with the law of the reimbursement or award of the car or in subparagraph C and the D with include the appropriate fee within other expense within accordance with subsection A and the D 2412 with the Title 28 U.S. Standard Code with 180 days of the enactment of the act of the Ministry of the Environmental Protection Agency shall in consultation with the Attorney General establish the published guideline with the amendment have the enforcement emergency response authority of the section existing statute with the Ministry of the Administrative Environmental Protection Agency evaluate the responsibility powers created by the Act with the sub-guideline with the shall extent of the practically consistent with the hazardous substance related shall include the minimum of the assignment of the responsible consideration response action issued with administrative order enforcement stand with the permits gathering information other hazards emergency powers and authorized by 1 section 311 C 1 308 309 304 A Federal Water Pollution Control Act 2 section 3003 7 3008 3013 7003 of the Solid Waste Disposal Act and section 1445 1431 of the Safe Water Drinking Water Act and section 113 114 303 of the Clean Air Act and section 7 of the Tax and Substance Control Act. Alright, your liability. Alright, section 107 with the announcement with the provision of the rules subject only with the defense set forth in section B with the owner of the operative of the vessel facility any of the person at the time of this will they have the substance owned and operative facility in which of the hazardous substance were disposed of any person with the contract agreement otherwise the range for the disposal treatment the range for the transportation or transport the disposal treatment have the substance owned with the possessed owned with the stuff of the person any other part of the entity with the facility with the incineration vessel owned with the operative with the any other part of the entity contained with the other half of the substance any other person with except for the have for the transportation, disposal, the treatment of the incineration vessel with the side of the life of the subversion from with which for the relief of the threatened relief will cover the incurrence of the response cover the or something shall be liable with an L cover the removal of remediation remedial action including the United States of the government state of the Indian or tribal not consistent with the national consent any other national call for the response incurred with any of the response consisting with the national consent plan damage with the injury with the destruction with the loss of the natural resource included the response call for the assessing with the effect of the industry destruction laws result of the release and the call for the health assessment health effects of the carried out study element of section 104AI. Or the amounts receivable recoverable in the action under the section shall include the interest amount of the recovery with the subparagraph A through G, they shall be the interest incurred with the later one over the day of the payment of the specified amount of the demand written to the day of the expenditure considered with the rate of the interest the outstanding unpaid balance amount recovered under the section shall be the same with the rate of the specified interest and the investment with the hazard substance superfund with the establishment of the subchapter A with the chapter 98 and with the Internal Revenue Code 1954 with the purpose of complying with the amendment to interest under the subsection term comparable to maturity shall be determined with the reference to the day of the interest occurring under the subsection commences 16. Therefore, shall no liability under section A of the section of the person otherwise liable to establish the preponderance of the evidence of the relief of the threat of the relief of the hazard of the damage resulting from their word solely an act of the God act of war act of the mission of the threat party other than employed by the agent of the defendant of the other on the words on those who act with the mention with the curve of the connection with the contractual relations existing directly and indirectly with the defendant, except for the sole of the contractual agreement, arrive at the published tariff, the acceptance of the carriage and common carrier or by rail. The defendant establishes a preponderance of the evidence that he established the UK with respect for the substance concerned, taking consideration of the characterization has something little on all relevant factors of the circumstances, and B, he took the precaution against the foreseeable to act for the mission and suffer the third part of this consequently again be foreseeable to resolve the start for the emissions. Any combination of the foregoing with the gas with the paragraph 2 with the subsection liability section of the owner and operative with the other responsible person for the relief of the hazard substance the incident releasing of the hazard substance shall not exceed any vessel with the incineration vessel will carry the hazard substance cargo residual $300 per gross ton or 500 million, whichever the greater. Any other vessel with the incineration vessel $300 per gross ton or $500,000, whichever the greater. If any other motor vehicle aircraft has a liquid pipeline facility as defined in Section 6101, Title 49 U.S. Standard Code of the Rolling Stock with $50 million just left for their men, the President shall establish the regulation, but not in event of less than $5 million for the relief of the hazard substance defined in Section 101.14a of the title of the the board's $8 million. This regulation was taken into account with the type of the location, storage, handling capacity, other matters for the relating to the likelihood of the release, and such the case for the economic input such for the limits on each for that such class. Incineration vessel any other facility specified in the paragraph C of the paragraph total of all the cost of the response plus $50 million in the damage on the title. Notwithstanding the limitation in paragraph 1 of the subsection liability of the owner and operator of the responsible person with the shall the full total cost of the response damage of the F1 and A1 and relief of the threat, relief that has the result of the willful conduct of the willful negligence with the private knowledge of the such person, the primary cover of the relief of this violation within the priority of the privity of the knowledge of the such person, applicable safety of the construction operation standard, the regulation B, such the person fails to refuse to provide applicable all responsible cooperation system requires that the responsible public official with a connection with the response activity to the national contingency plan respect the regulated with the carrier objectives subject to provision Title 49 of Standard Code with the vessel subject to the provision 33 and 46 of the United States Code subparagraph Air 2 that should be named the federal standard regulations. If any of the person who is liable to relieve the threat of the lease as substance fail the sufficient cover the property with the provide the removal of the remedial action under the President of the pursuant to Section 104, 106 of this Act, such person shall live liable in the state of the punitive damage of the amount with the equal to more than 3 times the amount with any of the cost incurred by the funds result of the failure to take the proper action the President of the rise commenced for the civil action given to such person recover the beginning of the damage with it shall in addition any of the cost covered in such pursuant Section 11 and 12 112 of the Act for the money for the mercy of the United States pursuant to the subsection be deposited in fund. Rendering care and advice in general, except for the paragraph 2 for the person shall be liable to own the cover the damages result action with admitted with the court for the rendering and system of the values according to the National Contingency Plan direction on scene with the coordinator of the appointment of the social plan, respect for the incident with the creating with the public health, the welfare, and the environmental result of the relief that has something threat of thereof. The paragraph shall not include the liability for the cause of damage result of the negligence of such a person. 2. State and local government. No state and local government liable with the total cost of the damage as a result of taking them responsible for the emergency created with the relief of the threat and relief of the hazard substance generated from a facility owner and other than person of the paragraph shall not preclude liability of the cost of damage as a result of the negligence and initial misconduct of the state and local government for the purpose of the preceding sentence. Reckless, willful, wanton misconduct constitute the grave negligence. Saving provision. Subsection with no altered liability in the person covered in provision. Paragraph 1, 2, 3, and 4 in subsection A of the section for respect with relief of the prevent and release concern. E1. Notification of the hold harmless similar agreement names but show the fact that the transfer owner operative with the name of the facility with the audio of the person liable for the relief of the threat with the release under the Section any other person of the liability imposed on Section nothing in the subsection B shall borrow any of the agreement ensure the both harmless and identify the party with the agreement and liability under Section nothing in itself including the provision of paragraph 1 of the subsection shall borrow the cover of the action over the owner operative with the other person's liability under the section of the guarantor who would have been by reason subrogation or otherwise against any person. Alright, F1 natural resource liability. In case of the injury, destruction, and loss of the natural resource of the subparagraph G of the subsection A of the liability of the United States government and to the any of the state natural resource state with belonging to the managed and controlled by parent to serve the state of the tribe natural resource belonging to the managed controlled but impertinent to the tribe the help of the trust the benefit of the such tribe belonging to the member of such tribe and such resources subject to the trust restriction and alienation provided here with no liability on the state of the Indian tribe shall impose with the subparagraph C of the subsection A with the priority the parties of to be troubled to demonstrate the damage of the natural resource combined with a specifically identified irreversible, irretrievable commitment to the natural resource environmental input, extending other comparable environmental analysis of the decision grant, parliament, and the license authorities with the natural resource facility project, otherwise operating within the permanent license as long as the in case of the damage of an Indian tribe and concurrent of the permanent pursuant to federal permanent licenses and issuing the permanent licenses not inconsistent with the fiduciary duty of the United States with respect to such of the Indian tribe. The president the president or the authorized representative of any of the state shall have the behalf of the public trustee with the natural resources to recover the damage of the recovery of the United States government of the trustee under subsection retained with the trustee without further appropriation only received restore the replay for the acquired equivalent natural resource of the recovered in state trustee under the subsection applicable available only with the restore the replay for the acquired the equivalent natural resource by the state. The measure of the damage of the action subparagraph C with the subsection A but not limited to sums then can be used to restore the replacement of the resource that shall not be double the recovery under this act. Natural and resource damages including the cost of the damaged asset, the restoration, rehabilitation, acquisition, same release, natural resource that shall not recover under the authority of subparagraph C with the subsection A with the such for the damage of the relief that had substance from the such damage of the result that have occurred wholly before the act. Designation federal, state, and official federal. The president shall designate the national plan published in section 105 of the Act with the federal officials who have officially behalf of the public trustee of the national resource of the Act with the section 311 of the Federal Water Pollution Control Act of such official they shall assess the damage, injury, the destruction, loss of the natural resource for the purpose of the Act with the section 311 the resources under the trusteeship of the upon the reimbursement state and federal officials discretion after the damage of the national resource of the state trusteeship. State the governor in each state shall designate the state of the who may act on the behalf of the trustee of the financial resource of the Act with the section 311 of the Federal Water Pollution Control Act with the notify the president of the designation of such state officials shall assess the damage of the natural resource for the purpose of the Act and such 311 the nature of the resource of the trusteeship. The rebuttable presumption. The term of designation to assessment of the damage of the national resource for the purpose of the Act and 311 the Federal Water Pollution Control Act may be made with the federal state trustee in accordance with the regulation promulgated under section 301T with the Act shall have the force and effect of the rebuttable presumption have the base on behalf of the trustee and administrator of the judicial proceeding under this act, the section 311 of the Water Pollution Control Act. Federal agencies for the provision of the federal agency section 120 of the owner and operative vessel shall be liable according to the section of the maritime law with the provide within section 111 and 14 without saying with the provision of act with March 31st, 1851, or the absence of physical damage of the prioritized interest of the claimant. No person, including the United States, any of the state, but the Indian tribe may recover the authority with the section of any of the response cost for the damage of the resulting application of the pesticide product with the registered with the federal insecticide, fungicide, radonicide. Nothing with the paragraph shall affect the modify of the way of the obligation liability of the person honoring the provision statement federal law, including the common law for the damages, injury, loss resulting in release and hazardous substance, removal of the remedial action, call for the removal of the remedial action. Substance recovered by any of the person with included in the United States, with the Indian state, and the Indian tribe, the response to cover the damage result and federally permitted release of the pursuing the existing law of the lieu of this in this section. Nothing in the paragraph shall affect with the modify any with the obligation liability of the person. Other provisions, state, federal law, including the common law of the damage and injury law for the resulting of the release of the hazardous substance with the removal of the remedial action with the cover the removal of the action and with the over the hazardous substance and additional cover the responsibility of the federal government in connection with the discharge specified in this section 10110B and C of the Recovery Act should have been brought in section 309B of the Clean Water Act. Liability established in section other than the law of the owner and operative with hazard waste disposal to which for the operator receive the permit on the subtitle C of the waste disposal of the act transfer the sum of the post closure liability fund established in section 232 of the act with the trust facility the owner and operative they have to comply with the requirements of subpart C of the solid waste disposal of the act regulation there is and under may affect the performance of the trust facility after such facility has been closed in accordance with the regulation condition of the permanent such facility for the surrounding area to be bound with the required for the rest regulation permanent condition of the period not to exceed the 5 years claiming closure of the damage of it there is a substantial likelihood of the mitigation officer with the relief of the confinement of the hazard substance or the risk of the public health and welfare of the occur. Such transfer of the liability shall affect within 90 days after the owner and operative with the facility with the administrator with the particular agency state with which have the authorized program in section 3006B with the solid waste disposal of the condition imposed with the subsection have them been satisfied with the 90-day period. Administrator emergency protective action state determines if the service facility complied with the condition of the proposed in subsection sufficient information has been provided with the demonstrator with the service complying with the administrator such the date shall notify the owner and operative with the service facility administrator funding and establishment of 232 with the act owner and operative such facility continue with the liability with respect to the facility under the section other law with the such for the time of the administrator such for the state determine the facility with comply with the administrator and all conditions of the imposed with the subsection determined by the administrator of the state of the facility with comply with the condition of the imposed with the subsection sufficient information has been supplied with the demonstrator complying with such final administration action purpose of the judicial review the requesting additional information shall be specified by the term as required. In addition, the assumption of liability owners and operative paragraph 1 of the subsection post closure liability fund established in 232 of the Act may be used to pay call for the monitoring care of the maintenance of the site, but the incur for the respond with the period of monitoring required in the hazard regulations subtitle C with the solid waste disposal act with hazard waste disposal facility meeting the condition of the paragraph 1 subsection. No later than 1 year after the date of the enactment of the Secretary of the Traffic to conduct the subject shall be able to submit the report thereon the Congress feasibility establishing qualifying optional system of the preventing private insurance of the post-closure financials responsibility hazard waste disposal facility to the subsection ability to apply with the such shall show the specification adequate realistic minimum standard to ensure whether they have such priorly placed ensuring that they will carry out the purpose of the subsection reliable to enforce practical manner of the test of the study shall include examination of public life for the incentive events and programs action necessary to make properly placed ensuring with the practical effectiveness operation option of the financial system of the post-closure liability provided by the Title 2 of the Act. Alright, no later than the 18th month of the day of the enactment of the Act, public hearing, the President shall rule to determine whether not feasible to establish one of the optional state system provided in insurance post financial responsibility has waste disposal facilities within the subsection apply with the President to determine the established qualification such system infeasible if he shall promptly public explanation responsible for the determination President determine the establishment qualification such system feasible shall promptly publish in the such determination. No later than 6 months after the affirmative determination of the proceeding after the public hearing, the President shall promulgate the adequate, the realistic minimum standards shall meet the minimum of the private place and shall be taken into account of the purpose of the action subsequent subsection rules, and then shall also have the reasonable expeditious procedures to which privately placed instrument of the plans can qualify meeting the minimum standards. Alright, in the event of the privately placed insurance plans, they qualify with the initial paragraph B of the person enrolled in complying with the terms of the plan, exclude the provision in paragraph 1, 2, and 3 of subsection, except for the requirement that they pay any of the tax or fee of the post-closure liability fund and Title 2 of the Act. President may issue such rule that take effective action necessary to actuate the properties of the net and standing suspension liability transfer the nothing with the training paragraph 1, 2, 3, and 4 of the section of the subsection section J of the section 101 111 the Act of the not liable with the transfer or as assumed with the post-closure liability trust fund established in 232 of the Act prior to completion and serve required in paragraph C 6 of the subsection transmission report of the survey of the both houses of the Congress with the authorization of the transfer assumption of the Act of the Congress following receipt of the success of the study report study option for the post-closure program study of the Comptroller General to conduct the study option program of the management of the liability associated that has waste treatment the over the disposal side of their facility complying with the policy that is set forth and hazardous solids waste amendment of 1984 assure the protection of the human health and environment program elements. The program referred to the paragraph they design the strip of the following with the incentive of the creative, with the maintainment of the shape of the management, the disposal of the hazard waste system, the strip of the protection of human health and environment. The public, measurement of the public reasonable with the confinement of the hazard waste and will be managed to dispose of safely with the resources to be able to address any of the problems arising to the company to call for the long-term monitoring care of the maintenance society. The person who the secret may come, the owner. The operative that has waste the facility will be able to manage the potential future liabilities to track the investment capability necessary to build an operative closure such stability manner with the ensure the protection of human health and environment and environment. C. The assessment of the study of the paragraph that include the assessment of the treatment that's over the disposal facility which have them and are likely to achieve the permit on the section 3005 of the solid waste disposal act likelihood of future insolvents for the the owner's operative of the facility separate assessment shall be made with the different class of this facility, the different class of the land disposal facility shall include but not limited to the current or future with the financial capability facility owner and operator of the current future cost associated with the facility, including the cost of routine monitoring, of the complying with the monitoring, corrective action, natural resource damages, liability damage third parties. Availability mechanism in which owner of the operator facilities can ensure the current with the future cost including the post closure when they will finance will be financed. Alright, D. Procedure. In carrying out the responsibility of the paragraph comptroller shall consult with the administrator of the secretary of competence of the Treasury and head of the appropriate federal agency. The consideration option with the conducting the study with the pick up the Comptroller General with the consider the various mechanisms combination of mechanism for the compliant and with the policy for the hazardous solid waste management for the 1984 for the purpose of the step forward and so paragraph the G to ensure the current and future costs associated with the hazardous waste facility include the post closure cost of the adequate finance in the greatest extent possible the owners and the operative with the facility mechanisms to be included but not limited to revision closure of the post closure financial responsibility requirements as well as C and I of the solid waste disposal. Like we're all volunteer risk of pooling and by owners and operators legislation requiring risk of pooling and by owners and operator modification post-closure liability fund of the previously established in 232 of the Act addition transfer liability under the subsection but include limited the transfer of some of the liability under the subsection only in the case of the insolvency of the owner and operator private owner insurance the insurance provided by the federal government co-insurance the insurance pool risk insurance that will provide with the private sector, that provide with the associated with the federal government, the creating of the new program, and then administration of the new with the existing federal agency, federal character, chartered corporation. Recommendation of the comptroller general, the consideration only option of the funding any longer. Any of the program under this section shall they be exempt within the necessary for the making of the recommendation. Appropriate committee of these of the Congress additional authority to implement such a program. Federal lien. And all the damage of the person liable to owners, the subsection A of the other owner and operator with the vessels on paragraph 1 of the subsection constitutes the lien of the favor of the United States upon real property rights of the property which belong to such person are subject to be enforced by removal of the remedial action and duration of lien imposed. The subsection shall arrive the later following. Alright, a time called for the first incurred with the United States with respect to the response action of the action, the time, and the person of the paragraph and the certified the register written notification potential liability, such lien with the continued liability with the cost of the judgment again for the right person arising out of the liability satisfied that becomes unenforceable through the operation of the statute of limitation provided in Section 113. Notice invalidity. The lien imposed with the subject of the shall be subject to the restriction of the approach of the hold of the security interest of the judgment, lien with the creditor with the interest of the perfect of the state law of before the notice of the lien that has been filed with the property office of the state or county or the governmental subdivision designated by state law with the real property with the lien is in located with the register of the whole of the security interest of the judgment lien and the creditor that are afforded by the same protections against the lien imposed with the subsection afforded with the state law again for the judgment and lien right to the secured obligation in which of the right at the time of the fulfilling with the notice of the lien imposed on the subsection of the state of not law by law designated one office of the receiver of the set of the notice, the lien of the notice, they'll be filed with the office of the clerk of the United States, the district of the district, over the real property is located with the subject in term of the purchase and security of interest, shall have the definition provided in subsection 6323A, Internal Revenue Code 1954. Action over the remedy. The call of the constituting lien over the recovered action of the rem over the United States of the district of the occur over the district of the removal of the remedial action occurring with occurred with the nothing in the subsection shall have the right of the United States to bring an action against any person from cover all the damages which such a person is liable under subsection A of this section. Maritime lien. All covered damages which the owner operative of the vessel liable under subsection A1 of the restricted relief of the threatened relief that says of the vessel the constitute the maritime lien over the favor of the United States over the owned vessel such as the recovered in the action of the remedial district court of the United States of the district in which the vessel may be found nothing in the subsection of the right of the United States to bring the action again for the owner and operator with the vessel with the court competent jurisdiction to recover such cost liability of fiduciaries. In general, the liability of fiduciary any of the provision act for the relief of the threat and relief that has something in the connection with the vessel of the facility with a fiduciary relationship. Fiduciary capacity shall not exceed the SSS of the fiduciary capacity exclusion. Paragraph 1 does not apply to the extent of the person liable with the act of the independently with the person ownership of the vessel facility with the fiduciary action taking the fiduciary capacity. Limitation. Paragraph 1 and 4 do not limit the liability pertaining to the relief of the threat and relief that has substance of negligence. Fiduciary call for the contribution of the relief of the threat and substance release. Safe harbor. The fiduciary shall not be liable in the personal capacity of the owner of this act. The undertaking the directing another person under the undertaking the response action under section D1 under the direction on the sync order of the designated under national contingency plan undertaking the directing and another person undertaking the lawful means of addressing heavy substance connection with the vessel facility. Terminating fiduciary arrest and the relationship that include with the term of the fiduciary agreement with the covenant warranty, other term of the condition that relates, complying with the environmental law, and monitoring and the modifying the enforcing the term of the condition, monitoring and the undertaking one or more inspection of the vessel facility, providing financial other advice with the counsel of the other party, financial and relationship with the settler and beneficiary, restriction, negotiation, otherwise altering term consideration for the relationship. Alright, H, administering a fiduciary vessel facility with a contaminated with the war fiduciary relationship began with a decline when taking any of the action described in this paragraph B through A for the definition of in this act with the fiduciary benefit that means the person that have the benefit in another party with the benefit of the trustee executed administrator custodian guardian estate of the guardian ad litem receive the conservative of the committee of the estimate and capacitated person, personal representative, trustee, including successor trustee, and agreement, the trust agreement, there's a similar financial agreement, the debt of security, the certified interest of the certificate, and some of the participation debt securities, other forms of indebtedness of which the trustee is not, and with the capacity of the trustee or lender. 11. Representative of the any other capacity of the administrator provide the public notice of the demonstrate the similar of the capacity described in the paragraph 1 through 9 of it does not include the person of the fiduciary respect over the trustee, other fiduciary assets with the organized primary purpose and gave the activities carrying with a trade or business the profit of the owner and life of the trustee of the other fiduciary was created with the part of the facility, one with the more to sell and plan to recover the incapacity of the natural person, and the person acquired with the ownership of the control of the vessel facility with the object with the presumed purpose of the providing liability with the person of the other facility. Fiduciary capacity. The fiduciary capacity means the capacity of the person holding the title of vessel facility, otherwise having control over the entry of the vessel facility, pursuing the exercise of the responsibility of the person and fiduciary, saving the with nothing in the subsection effect of the rights of the immunity of the defense that are available under the act, otherwise applicable to the person subject of the subsection, with the liability of the person private right with the action of the fiduciary any other person. No effect of a certain person but on the subject action of the person applied with the act for the capacity other than fiduciary benefit capacity for the capacity directly and indirectly benefits of the trustee fiduciary relationship with the beneficiary fiduciary respect with the same fiduciary estate, but as a fiduciary is receive the benefit that exceed the customary responsible compensation incidental benefits permitted with the other applicable law. Limitation of the subsection does not preclude the claimant under the action of the answer for the estate of the trustee of the fiduciary, not employing agent of the independent contractor, and retain fiduciary. Or your D micromos exemption. Generally, except in paragraph 2, with the person shall not be liable with respect to the response of the cover of the national priority list under paragraph of the act of liability based solely on the paragraph 3 and 4 in the subsection A, which except the provided in paragraph 4 of the subsection demonstrate that the total amount of the material contained with the heads of the parts of the person arranged for the disposal of the treatment, arranged for the transport and the trade from transport with disposal treatment, they will accept with the disposal of the treatment of the facility with less than 110 gallons of liquid material with less than 200 pounds of the solid material with a seventh grade or lesser amount of the amount of the material of the damaging. Remember the regulation, all parts of the disposal treatment, the transport concerned with them paid for 2001. Alright, exemption. Paragraph 1 shall not apply when the name of the cave of the heads of the president determine the material contained with the heads, no other than paragraph 1 contributed to the significant with the contributed with the significant individual with the aggregate of the capital responsible for the national reach for the restoration and respect of the facility. And person of the payable to comply with the information required of the ministry of the disobedience issue with the president of the act with the impending of those through the actions and inactions to perform with a response action the natural restoration with respect to the facility. A person that has convicted with a criminal violation of conduct with the explanation would apply with the conviction not be not deviated or appealed otherwise. And then you have no judicial review determination president with the paragraph 2A, but there shall not be subject to judicial review. Your non-government third-party contribution act, and in this case, the contribution act responds with respect to the response of the facility with the national priority live with the part with the federal, state, and local governments under the act, the burden of proof on the party beginning bringing with the act to demonstrate the condition described in paragraph 1A, B, of the subsection are met. Municipal solid waste exemption. Generally, except the prime paragraph 2 of the subsection not be liable with respect with the response of the facility in the national priority list on paragraph 3A with the subsection A with the municipal solid waste disposal of the facility person except the provide paragraph B. Have the 5 of the subsection demonstrate the person is an owner of the property with a leaser, owner or leaser of the residential property with all the personal municipal solid waste with the respective facility. Business and the include the parent and subsidiary affiliated with any duration 3 taxable years receiving the date of the transmittal with a written notification for the president potential liability under the section whether the average is not liable to 100 full-time individuals equivalent thereof the small of the business concerned with the meaning of the Small Business Act of the Title 15 U.S. Code 631 and 10 sequence from the with the of the municipal solid waste attributed to any with respect to the facility organized described in section 501C with the internal revenue code 1967 but this is section 501A. Just code during the taxable proceeding the day of the transmittal written notification of the president potential liability under the section employed with more than 100 part of any paid individual location generated all of the municipal solid waste attributed to the organization respect with the facility of the person of the subsection determined affiliated with the means for the terms provided by the definition agency submit business concerned with the regulation promptly give the small business administration in accordance with the Small Business Act. Exemption paragraph 1 shall not apply but the case of the president determines that municipal solid waste referred to in paragraph contributed significantly with the individual aggregated with the call for the response action national resource restoration in respect to the facility. And then let's see. Or the person has failed to comply with the information required of the administrative subpoena with the president of the act, the person impeded with the bending of the action and inaction of the performance to respond to the action national resource restoration with respect to the facility. No judicial review the determination of the president under the paragraph 2 shall be served with the review the definition for the municipal solid waste general for the purposes of the municipal solid waste may be the waste material generated with the household of a single multiple family residence generated with the commercial industrial institutional entity with the extent of the waste material essential for the same of the waste for the nominal generally with the household of the collective with the disposal of the other material municipal solid waste for the part of the normal municipal solid waste collection service with examination relative to the quantity of the subsequent grade relative to the quantity of the heads of the contain the waste of the material during the typical single-family household. Example of the municipal solid waste for the paragraph A with the food yard waste for the paper, the clothing, applying for the consumer product package for the disposal of the office suppliers, cosmetics, for the metal, sold food containers, to elementary, secondary school, sanitary, lab waste, household set waste exclusion determined municipal solid waste that does not include the combustion and action area with the score to cover the facility municipal incinerators. Waste material the manufacture process the operation, including the pollution control of the operation, essential with the same with the way for non-normally generated with the household. Burden approved. Then keep the action with the respect with the response of the Commonwealth facility with the national priority lives under Section 107 and 113 as part other than federal, state, and local government with respect to the municipal solid waste disposal after January 1st to April 1st, 2001. Any part with respect to municipal solid waste disposal April 1st, 2001, the burden of the Bartley bring with the according with demonstration for the condition of the described in paragraph 1 through 4 with the exemption, and these organizations described in paragraph 1, B, and C with the not permitted certain action not permitted the non-contributory action be brought by any part of the on other than the federal, state, or local government under this act, respect with the circumstances described in paragraph 1A. Costs and fees of non-governmental under the commons for the day with the enactment of the subsection contribution act for the act that should be liable to defending with the response for the call for the defending with the action, include with the responsible attorney fee, the expert witness fee, and if then defendant is not liable to contribute contribution based on the exemption under the subsection and subsection O. Continuous property with non-considered to be owned or operated with in general the purpose of the own operative real property that continues otherwise similarly situated with the respect to the that they may be contained with the relief of the threat and relief of the hazard substance form of the property not owned with the person shall not be considered the owner and operator of the vessel facility under paragraph 1 and 2b subsection with the reason of the contamination if person did not cover the contribution with the relief of the threat and relief of the person's potential level of affiliate with any of the other person's potential level of reasonable with the health of the facility, any of the direct and indirect familial relation with the control, contractual, corporate, financial relation, but other than the contractual, corporate, or financial relationship with the creative by the contract, the sale of goods and services as a result of the reorganization business and the potential liability of the person in a reasonable step at the top, then counting, continuing release, preventing the threat and future relief of the preventing and limited to have the human environmental natural resource exposure hazardous substance relief in the form of the property owned other than owned by that person. The person full cooperation systemly accept the person authorized and conduct the response action national resource restoration vessels from that has been a relief and threat and relief include the cooperation access necessary of the installation integrity with the operation made with the aim of the completion of the response action natural resource restoration vessels. The person complying with any of the land restrictions established relied with connection with the response action facility and does not impede with the effectiveness and integrity of the institutional control employed within connection with the response action person compliant with any of the request information administered with the subpoena issued with the present owner of the act. The person provided the legally required owner notice of the respect for the discovery of the relief that has something facility. At the time of the which for the person acquired with the property for the person connect the property inquired with the meeting of the 10135B with the respect for the property did not work with any of the reason of the property with the conducted could be contaminated with the relief of the threat and relief of the one or more has the substance of the real property not owned or owned or operated. Alright, B. Demonstrated the qualify the person described in subparagraph A with the person qualified to respond preponderance for the evidence of the condition clause 1 and then through 6 8 with the paragraph that has met with the bona fide prospect of the person that does not qualify the person described in the paragraph that because of the person has been reason to have the knowledge specified in the paragraph A with the 8 of the time of the acquisition of real property qualified the bona fide of the prospect of the person for the paragraph 10140 with the person otherwise described in the section. Groundwater. With respect to the hazards of one or more surface not in property with the person with the continuous property owner with the entry of the groundwater beneath the property with the person solely the result of the subsurface integration aquifer subparagraph A3 with the shall not require the person to conduct the groundwater investigation store the ground with the water remediation system example is conform with the policy with the environmental protection agency concerned with the owners and operative property concerning with the contaminated aquifers dated October May 24th 1995. Effective law with respect to the person described in subsection nothing in the subsection limited to defend the liability of the available of the person owner of the provision of the law and impose the liability of the person that is not otherwise imposed with the subsection A. Assume that the administrator may issue the assume that no enforcement action of the act that is initiated against the person described in paragraph 1 of the grant person described in paragraph 1 of the protected against the cost recovery contribution act of the section 113F. Alright, then we're going to read section 108. Alright, prospective prior purchase of the windfall of the lien with limitation liability without subsection bona fide with the fine with the purchase of the potential liability relief the threat and relief of the based solely on the bona fide the aspect of the purchase of the been considered to be an owner and operator with the facility shall not be liable as soon as along with the bona fide purchase prospective purchase of the design and the performance of the response action natural resource restoration. Alright, the lien if there is uncovered response incurred with the United States of the facility with which the owner of the facility is not liable to produce from the paragraph 1 of each for the facility described in paragraph 3 of the United States that have the lien facility with a made agreement with the owner and obtain with the owner of the lien either property or other assurance of the payment of satisfactory administration for the uncovered response costs. Condition of the condition referred to in paragraph 2 of the file of the response action with the recovered unrecovered cost of the United States carried out the facility framework of the response action with the increase of the fair market value of the facility above the fair market value of the facility that existed before the response action was initiated. Amount of duration of the lien under paragraph 2 shall be the amount with not exceed the increase of the fair market value of the property attributed to the response action at the time of the sale or the other disposition of the property, the shall or other the time of the which for the cause of the first incurred with the United States with respect to the response to the action of the facility shall be subject to the requirements of subsection 1, 3, and I3, and it shall continue with the until earlier with the satisfaction of lien and sale of the other means, or another with any statute limitation under section 113 recovery and all the response costs incurred at the facility. All right, financial responsibility, section 108. I'm going to cut the tape there.